Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is, Are You Hipster Enough? The new Brandeis School of Antitrust and how it's changing the agenda. Antitrust has a long history in this country, going back more than 100 years, and it's gone through it's gone through an evolution and different cycles. The current era we are in has been heavily influenced by the Chicago School of Economics, and we use the term consumer welfare standard to talk about how we think about antitrust and priorities and enforcement. There is a debate that is going on. People are challenging whether that is the right way to think about it and whether we should be approaching it from a different direction. And today we are going to explore some of those questions and maybe how to think about antitrust a little bit differently. My co-host today is Christina Ma.
Thanks, John. As you mentioned, today we're going to learn a little bit more about, I shouldn't say challenges to, but alternatives to the consumer welfare standard. It's an ongoing debate both here in the U.S., the EU, and elsewhere.
Christina, who's our guest today?
We have Tim Wu, who's the Julius Silver Professor of Law, Science, and Technology at Columbia Law School. He's also the author of a number of works, including Network Neutrality, Broadband Discrimination, The Master Switch, and most pertinent to our conversation today, The Curse of Bigness. And
what are we hoping to get out of the conversation today?
We're hoping to challenge, I think, the way we think about modern antitrust law, think about what everyone has been talking about, what people have coined as hipster antitrust or the new Brandeis School of Antitrust.
Okay, yeah, the term hipster antitrust is, in some ways, is almost pejorative. So I'll be interested in hearing what our guest has to say about that label. But let's bring him in. Professor Wu, welcome to our program.
A pleasure to be here.
So Professor Wu, thank you for joining. It's funny, hipster antitrust, to the extent that it's pejorative. Things are always pejorative before they become mainstream. And I think that the ideas that you put forth in The Curse of Bigness, which is a very interesting read, and certainly recommend that to our to the viewership or the folks who are listening in. Can you tell us a little bit about what the new Brandeis School of Antitrust is and what it's intending to do?
Well, it is new, but it's also old, I think. I see myself as part of an antitrust revival movement, an effort to kind of bring antitrust back to its origins, and a reaction, I think, to our current economic conditions. There has been an enormous growth in corporate concentration over the last 20 years. There's been a rise in inequality. There's an age of a lot of more populist, extremist politics. It's a lot like the early 20th century, late 19th century. And the sort of classic American answer to some of these challenges we're facing has been an anti-monopoly tradition, antitrust tradition. And I'm one of those who believes it's time for a comeback. And that's basically, in a nutshell, all this is about.
And so, as John had previously mentioned, the prevailing perspective today is that when we're evaluating whether or not, whether it be a Sherman Act or a Clayton Act issue, is that we're looking at it from a consumer welfare standard. What does the consumer welfare standard mean to you, and why is it not, in your mind, sort of a sufficient or adequate standard for the challenges that we face today?
I see consumer welfare as sort of a recent fad, 30 years or so. The antitrust laws have been experimenting with a very sort of a stricter version of consumer welfare, and I think since that time, somewhat noble in its aspirations, depending on who's been applying it, based on this idea we want antitrust to be a little more scientific and more technocratic. I think it started to show its problems and its failings, and that antitrust should return to what it did before, which was protection of competition or protection of competitive process. The idea of welfare and consumer welfare and measurements of it is really a new thing and something that I don't think has gone that well. And there's a number of reasons. I don't want to spend the whole time on it, but I think it works pretty well for horizontal price fixing. We can get technical. You can see that, raise prices for its consumers. Most of the concerns that you have surrounding exclusion, and many of them surrounding mergers, are not captured well by this sort of narrow focus, what tends to be a narrow focus on price. Because, when you exclude a competitor, let's say Microsoft, classic case, knocks out Netscape, the price harms from that are not always obvious, but the harm to competition is a lot more obvious. So, there's, get into this a little more, there's people who think you can rehabilitate consumer welfare, make it better. People like me who think the brand is damaged irreparably, but that's the discussion we're having.
I see. So, to your point, there are folks who say, well, we can capture harms to innovation, harms to nascent competition, all within this lens of consumer welfare. We don't need to focus on price. We can focus on quality and other components. But it sounds like that to you, there's too much tied to the notion of consumer welfare that's strictly to price.
I think what's happened is that consumer welfare standard in front of judges, often even in agencies, comes down to a burden on the plaintiff to show a price effect. Mm-hmm. A lot of mergers end up that way. And so therefore, even though we often, I worked at the FTC and other places, we talk a good game, but would always be looking for these price effects. And I think it has, it's just not price effects in a very narrow consumer-focused perspective. A lot of the stuff that really matters is very hard to measure. The damage done to competition by exclusion, the damage done by a 3-2 merger. You can predict that maybe or 4-3. You can predict that maybe it'll raise prices, but there's a lot of structural innovation harms, dynamic harms, and so I think we need, almost for the sake of the law, that the law do what it was supposed to do, adjust or either go with highly extended. I mean, I don't completely give up. I'm a consumer. Many of my best friends are advocates of improved consumer welfare, and so we're sort of allies in this cause. But I think the ideal thing is to really say it was a mistake. We got a little too infatuated with Chicago school thinking for a while and go back to what actually courts often do anyway, which is the protection of competition, protection of competitive process standard.
We've talked a little bit about the Chicago school, and I think what you would hear from proponents of that school is that that's all about science, right? That this is the reason the consumer welfare standard is so right is because you can prove it with math. What would be your response to that?
First of all, that's if the consumer welfare standard is supposed to be the gold standard of predictability, it really hasn't worked out that way. It turns out that it isn't a science. It turns out, as I said before, a huge number of things we care about are not captured by these quantitative methods. Economists will be the first to admit there's so many things they can't measure. How do you measure? Even just take the Microsoft case or any case where you're knocking out a nascent competitor. How do you measure the harm to the competition in terms of price by that? It's very hard. And so I just think it's missing way too much. It is predictable that you'll have predictable under enforcement. I think some people like that about the standard, but it is both not predictable and predictable. Anything it leads to massive under enforcement. So that's the problem.
So in your book, you kind of propose a couple of things under sort of the new Brandeis agenda. Broader and tougher merger standards, a democratization of the merger process, a greater willingness to go after big firms and to break up those firms, a concept called market investigations, sort of a non-judicial way of evaluating an industry that's sort of almost too complacent after a long period of time, and changing the dialogue to protecting competition. I think those are all admirable sort of end agendas and goals. I think as a private practitioner, something that we often struggle with is how do we then advise clients? How do we talk about having predictability in the agenda and what we can tell, corporations about what they can expect in that world?
Right. So that's a good question. Now, before antitrust supposedly became predictable, I don't really think it became predictable. Attorneys advised firms, and it wasn't impossible. And I don't think it'd be impossible with some of the changes that we're discussing. Antitrust goes through periods of greater activity and lesser activity. I think the lawyer's job remains the same, which is give their best guess as to what the courts will do. In some ways, if you go back to something like structural presumptions, things become more obvious. If you're going to say pretty much most 4-3 mergers shouldn't be allowed, well, that's the advice. The general rule is 4-3. Or if you have a rule about exclusive dealing over 30%, you can give a relatively more straightforward answer. I don't really believe in excessive per se rules, but they were easier to advise on. In fact, the most difficult thing is rule of reason. And so I say that. I also say, while I respect people who practice law, that predict, how hard or easy it is for counsel to give advice is not the only thing the law cares about. It cares, in fact, obviously about the broader effects for the economy. And I think that we have an overconcentration problem. I think we have passed on way too many mergers. Yes, maybe that's more predictable, but I think the broader balance favors stronger enforcement.
What are some of the? Do you have any examples in mind of
Sure.
decisions, whether they're merger decisions or conduct decisions that might have been decided differently if we were applying a Brandeisian standard as opposed to a consumer welfare standard?
Yeah, I could go on for this for hours, so I'll be careful to limit myself. I don't think the airlines should have been allowed to merge down to 3 major airlines. I think that was a major mistake, and a more structural approach would have opposed that. I don't think Ticketmaster and Live Nation should have been allowed to merge, two almost monopolists into a vertical merger. I don't think T-Mobile and Sprint should have been allowed to merge. I think that was a mistake that's going to hurt consumers. I have some doubts as to whether Dish is going to provide an adequate replacement. I don't think the tech firms, particularly Facebook, should have been allowed to buy some of the most dangerous competitors. I'm thinking particularly of Instagram, WhatsApp, but there's others too. They have sort of 97 unchallenged mergers. I could go on. I think in agriculture we've allowed too much vertical integration and too much horizontal integration. So actually, some of my greatest criticisms are in the merger space when you get down to it. We haven't had a huge number of conduct cases. That, in its sense, is its own problem. But if I put my finger on it, it's like lost, say, 20 years of green light on the merger side. There are some exceptions, but and I think the effects have been real. I think in corporate America, there's a sense that it's basically a green light for mergers that all maybe except for merger to monopoly, but that one way or another they're able to get these things through. And I think that has been a bad thing overall for the competitiveness of the U.S. economy.
So I want to touch on 2 things that I think struck me as I was reading the book. One is sort of this notion that bigness, irrespective of actually having market power, is itself a problem. That having a loss of public power to private power is itself a threat to democracy itself, and that once corporations become so large and powerful, they sort of, as you say, Brandeis feared that they would take a life on their own, becoming increasingly insensitive to humanity's wants and fears. How do we while I recognize that the sort of the trust busting era was a solution to what Brandeis viewed as a problem, 50 years ago, how do we think about that in an era of globalization, where our national corporations would have to compete with multinational corporations? And a topic that I think is gaining traction in the corporate governance circles is this notion that corporations can start to measure themselves on standards other than profit. So they should care about environmental and social considerations. And if we create standards around other factors that may be important to society, maybe corporations won't be as, these big evil corporations that we otherwise would think of them as.
Right. There's a lot in that question, really three questions. But, I'll try to talk about each of those topics. And I didn't even have talked about hipsterism or, I go to a decent number of antitrust events. I don't think I've ever spotted a hipster at one. So I don't know if it's supposed to be a hipster movement. It's not, or maybe they're just wearing suits. I don't know, with slightly thinner ties. Slightly thinner ties.
I'm trying very hard.
In a certain way, you've got something going on there.
Yeah, something. I'm not sure it's that. No, it's not. It's not that, but yeah.
Maybe the kind of Bill Gates 90s look a little.
I'm going to need to talk to my wife when I get home, and we're going to have to do a redesign. But I'm sorry. Go ahead.
Yeah, sorry, we got off blown off chart off course there, but no. So the political aspect. So partially, I don't think it's a job of attorneys, Justice Department or FTC or states to sort of be thinking case by case, what are the politics of this and how are we going to, but it is the overarching, I think, interest of the law is to put some constraints on private power, to serve as some limits to monopolization and oligopoly power. And, that happens by pursuing cases appropriately. And I don't think it should be forgotten that that's the purpose of the laws. Not the only, but a big purpose of the laws. That people were afraid of the power of monopoly, afraid of the corruption of government, afraid of just too much unaccountable private power. And I think those concerns have come back. I think they've transformed American politics. I think the reason I think that socialist solutions and also sort of further right stuff is coming back is that people feel powerless, and they don't think the economy works for them. They're sort of afraid. And I think one of the things I like about antitrust is it's not unbridled capitalism and it's not, Marxism or state socialism. It actually goes in a very different direction, which is like try to control power, private power, as opposed to, have it either run by dictatorship of the proletariat or just let it be. So that's why I like antitrust. Now, I got to remember your second question. I remember the third one was about
globalization.
Globalization.
Then sort of the ESG consideration.
So one of the questions that comes up is, should we really be considering antitrust scrutiny of America's greatest companies when they're in this global fight? Maybe China will win and so on. And I have strong feelings about this. I think it has always been the best American tradition not to establish or worship national champions. I think we differ strongly from Europe, South America, and Asia in this. All those countries have, at various times in their history, even now, say these companies are champion. They're going to go out and battle the rest of the world. We need to, give them all the support we can. I think over the long term, that leads in disastrous directions. Take a country like Japan, was chasing around the United States in the 70s, 80s, bet hard on a few national champions. What were we doing in the United States at the time in the 70s, 80s? AT&T and IBM were the great American tech industry. And what do? We broke them up and tried to break them up in the 70s and 80s. And what did that do? It created a lot of room for a whole bunch of new companies like Apple, Microsoft, Intel. These were the startups of the 70s and 80s. And they had room to grow, and they ended up dominating the new tech economy. Japan never did anything. They still roughly have the same companies that were around in the 80s. And when's the last time you heard of, Japan is still a very wealthy country, but they missed the internet revolution, missed the personal computer revolution, and have kind of sunk into a completely different status. I think China could make the same mistake. I mean, China right now it's all about 5G or it's all about AI, and those might be good bets, but they might be bad bets. And so I don't think I think antitrust is a way of keeping our best companies honest, and forcing them to deal with competitors straight up. If they're better than you, they're going to beat you. We're not going to let you have a pass on anti-competitive conduct. Finally, your third question is about changing standards for corporations. This is a whole other huge conversation. Should something other than shareholder welfare matter? I actually agree with that. So I guess I'm against welfare in all forms or something. I sound like an 80s Republican. I'm against welfare, corporate and corporate and consumer. I'm not against it. I just think the better view of what corporations should do should be a little broader. I believe members of this law firm where we're sitting have some of those views as well. Marty Lipton is the one who is often saying that. So now, how does that interact? It's a good question. I'm not sure if it's fully relevant. I think that antitrust is concerned with whether firms are behaving anti-competitively or not whether they're polluting too much. And I think those are actually different concerns. You could have a very well-meaning green kind of corporation that strangle its competitors in the backyard with frequency, and I'd still say they should be subject to the antitrust laws.
So Professor Wu, if we wanted to, if the leaders of this country found your position to be persuasive, what would they have to do to implement it? And the reason I ask that question is because you talk about the importance of implementing it in the merger world. I don't believe there's been a Supreme Court case involving mergers for many years.
That's exactly right. So, big things have small beginnings. I will be the first to admit that in some ways the deck, or at least the courts, are stacked against me. And particularly the Supreme Court, which if you look at Supreme Court often lags, but other than activists, most of their decisions of the last decade or so, American Express being most recent edition, have not been exactly neo-Brandeisian, let's put it that way. So one route is Congress. I think there's a lot of bipartisan support for a different approach to antitrust. I'm often surprised to have Republicans, maybe I shouldn't be surprised. I think that the Republican Party is asking its own questions. They've certainly changed their views on trade, and parts of the party, and parts of the party are changing on antitrust as well. And so Congress can overrule a lot of the cases it doesn't like. It could. There's the Amy Klobuchar bill that would create different standards for mega mergers. I think that would be almost the most straightforward way of doing it. A new president could have the merger guidelines rewritten and say this is how we now see things, this is how we interpret Clayton 7, and we're owed deference on that. And finally, I think attention to the appointment of judges and what the judiciary, what views they have. For some time now, the Democratic Party in particular has been pretty strict about sort of civil liberties and that aspect, social justice. But on economic issues, have been kind of like anything goes. And I think it's time to, if the Democrats come back into power, even with Republican appointees, start asking harder questions about their views on the economics.
So, Professor Wu, this is really helpful. I was wondering if we could shift gears a little bit, and wanted to ask you a couple of questions that aren't directly related to this topic. First, it seems like you have a lot of fun being a law professor. What's fun about it? Why is that a good job?
Oh, that's a great question. The off the cuff answer is the three best reasons to be a law professor are June, July, and August. But that's that's a little flippant. What I think is the greatest thing about being a law professor is you have the luxury of trying to figure out, what do I really think about this? And, not having to sort of respond to the moment, but think, what do I think? Go back. It sounds like a cliche. You get to speak your mind, but it is one thing I find when I've been in government for a long time. You're always sort of in the midst of a case or something. It's nice to have that luxury. I don't know if that's exactly fun, because sometimes you get kind of tormented, but you do get to sort of play around and like throw some ideas out there and see what happens. I've been throwing, I guess I would describe my jobs as throwing spaghetti at the wall. I used to work in marketing as well. When I was more junior, I was like, net neutrality is the right principle, and that got some traction. Right now, I've been trying to power antitrust revivalism, and I just something about throwing things out there and being in the dialogue that I find very enjoyable.
And what advice would you have for younger lawyers about how, if they want to practice in antitrust, what should they do?
One thing that's nice about antitrust is compared to, say, First Amendment law or personal international, there's a lot of jobs in antitrust. And the route is relatively straightforward. You go to practice for a great firm or go into government. It's a healthy community. There's a great ABA section. It is actually one of the areas where I can confidently say, I say in my antitrust class, this class could change your life. You might either find you hate it and are bored, or you might really like it, and your career might end up being in this area. And I can say with some confidence that will be a good career. And that's one thing I like about being in this field.
Last question, Professor Wu. Tell us something interesting or unusual about yourself that we wouldn't know if we just knew you professionally.
Yeah, my recreational interests are kind of veer towards the red state style. We have a house in the country. I have an enormous and embarrassingly gas-guzzling four-wheel drive vehicle. I like fishing. I like sailing. I like to just be in the outdoors. And I don't know if you would know that. I think I'm also a professor, sits in an office, and smokes a pipe and stuff like that. But I have another side, kind of the outdoorsman side, I guess, that you might not know about me.
Do you ever smoke the pipe in the four-wheel drive car?
No, I keep that in the office.
I see. Okay.
I keep that in the office to scare my students off, and I don't actually smoke it, but I point to things with it.
So I work at a firm that has a very large non-U.S. component, and I like to tell my non-U.S. partners that I often call them in the morning when I drive into work. I like to tell them that I drive a pickup truck and that there's a dog in the back and a gun. Between us, I drive a Prius, and I think they would be very disappointed if they found out, I was an American who did that, because I think they would much rather have someone like you as their American partner. With your gas.
I have to admit, in the purpose of full disclosure, my other car is a Subaru. It's actually four-wheel drive, but the non-off-road vehicle is a Subaru, which is more in line with the professor image.
All right. Well, with that, let's go to our final segment, which is called The Curious Hat.
And now it's time for The Curious Hat.
All right. Professor Wu, in my left hand, I have an actual hat that has actual questions in it. I'm going to reach into the hat and pull out a question. It's on an index card, as you can see. And I am going to ask you this question. Okay. Question number 25. Do you currently have any pets?
Oh, do I have any pets?
Pets.
Oh, no. I have two children.
Okay.
Who are my pets? My beloved pets. So no.
Next question.
No
next question. Okay. Oh, here's a good one. Professor Wu, if you were stranded on a desert island with a DVD player and could only bring 3 movies, what movies would you bring?
Oh, that's a good question. I would bring Lawrence of Arabia. I bring long movies, you see. I would bring Pulp Fiction. And I would bring the last Billy Elliot.
And my question for you then as a follow-up is, what is the unifying principle between those 3 movies?
I like them. No, actually, I'll tell you a different thing. Other than Pulp Fiction, there are movies about identity. And as someone who is half Taiwanese, half British, born in the States, grew up in Canada, a lawyer, part-time journalist, delves in all kinds of fields. Identity questions have always been interesting to me.
Well, that's great. And with that, we thank you, and we will see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.